We are back and spicier than ever, folks. I guess that's what happens when you turn 29 and you are on that cusp of almost being 30 and being in your final year of 20s. I'm fine. Are you fine? I'm fine. As it was an extremely eventful week last week for our favorite DA's office, Norfolk County. Detective Lieutenant Conehead Brian Tully gets rehomed. Another Betero bombshell is dropped, alleging in the latest installment of the Betero letters, Mr. Morrissey, of using a personal iCloud account to send an email to trial court administrators expressing his grave concerns following a Stoughton District Court judge denying a restraining order request against Turtle Boy for Chris Albert. Oh, but wait, there's more. David Traub, Meatball, official mouthpiece for the DA's office, also follows Lynn Beeland, the ADA whose name was all over the correspondence between the U.S. Attorney's Office and Morrissey's office. Yes, that Lynn Beeland, or Bland, or however you want to say her name. Yes, David Traub, the guy who looks like he was... this looks like the set of a Dan Schneider production. I'm not even gonna front. But that's not all. There's more. The Commonwealth never ceasing to surprise, as they have filed a official request to retrieve records from Bill Reed's, yes, Karen Reed's elderly father, his phone records, because of the phone call that she made to him that night, the night that Officer John O'Keefe was unalived. We also learned how much exactly Norfolk County taxpayers paid to prosecute Karen Reed the first time around. According to Boston 25 News, receipts and invoices showing it spent $43,985.05 prosecuting Karen Reed, but that figure does not include salaries, overtime, nor records of expenditures that disclose confidential investigative strategies and techniques. Yes, of course, because leaf blowers cost a lot of money these days. Actually, they probably do. But, I mean, still, you gotta factor in the solo cups and the stop and shop bit. I mean, I wouldn't be surprised if they used bungee cords to also secure the scene, or toilet paper, right? Started TPing off Brian Albert's home. Yes, it costs grands. Hundreds, even. We also learned that our favorite judge, Beverly Cajones, why can't I say that word? Regional Administrative Justice, will in fact remain on the bench for the Reed trial. Which, I mean, I already have questions, lawyer friends, because if this wasn't already a conflicting issue, I mean, if you're not supposed to be in the rotation, she's also the presiding judge over the Brian Walsh case, and as we know, Brian Walsh, there's a lot of the same cast of characters. It's the same DA's office, and it's the same lead investigator, who we have now learned will not be called as a witness, at least via the Commonwealth, for that trial. So my question is she going to still continue to be the presiding judge on that case as well as this case? There's a whole lot of crossover going on in this season, and I don't know, I just ain't having it, but we have loads to talk about in today's video. Hello, welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including this breaking news about how Judge Beverly Cajones, or Cannoli Oil, will no longer be the Regional Administrative Justice in Norfolk County as of January 1st, 2025, which again, a lot of people are asking, well, girl, isn't the Reed trial scheduled for January 27th. Now, what does this mean? She's no longer going to be head bitch in Norfolk County in terms of the trial courts, right? So according to the Boston Herald, Norfolk County judge who declared a mistrial in the first Karen Reed trial will return to the bench for the highly anticipated season 2 of the Karen Reed trial, according to the state's trial court. Superior Court Justice Beverly Cannoli Oil has become a household name throughout the region amid the constantly talked about unaliving trial. That is the understatement of the century. She will once again grace our presence and be seen on televisions, a TV near you, and all over the interwebs for the second Reed trial. Judge Beverly Cajones will continue to serve in Norfolk County, so this is via a spokesperson, Jennifer Donahue. She'll continue to serve in Norfolk County in 2025 and will preside over the Commonwealth versus Reed case in January. But what about the Brian Walsh case? Because again, there's a lot of familiar faces, aka Chip Proctor, who will not be called as a witness, at least for the Commonwealth, but I'm sure that the defense team for Brian Walsh is going to call him. I mean, I don't see why you wouldn't take that opportunity to. The Norfolk County judge has been a Superior Court Regional Administrative Justice for the county, but that term is coming to an end. So this is more from the spokesperson. In a Superior Court, regional administrative justices and other leaders serve in their leadership roles for 3 years, after which they rotate out of them, barring exceptional circumstances, whatever the heck that means. What, you don't want more Venmo screenshots appearing in the pre-trial hearings, Bev? For that reason, several administrative justices and other leaders will in 2025 rotate out of those roles, including Cannoli Oil from her role as regional administrative justice in Norfolk County. While continuing to serve as judge in Norfolk County, Cannoli will become the chair of the Superior Court's Criminal Committee. So not only does she get to stay, but she gets upgraded to the Superior Court's Criminal Committee. She becomes the chair. She gets a promo. She gets a promotion. Now, just jumping back real quick to this Turtle Boy article, in Reed's case, Karen Reed went in front of both Cannoli Oil and this other judge, Judge Peter Krupp. And in July of 2023, Judge Daniel O'Shea was reassigned to the main courtroom where the Karen Reed case was being heard. And again, we saw this happen a couple of months ago too with the former prosecutor of the Michelle Carter case. I had to think about it for a minute. The Michelle Carter case, the girl from Plainville, right, who encouraged her then boyfriend to unalive himself, and he unfortunately did, and she was successfully convicted. She's now out. I think her name's Katie Rayburn or Rayburn. And we saw her name appear up on the docket, and a lot of people are like, holy smell. I mean, I literally posted about it, and then the next day I was like, no, that was just a clinical error or clerical error, right? Something that Bev, I guess she was playing around in there, right? Maybe they had a couple of new buttons and plugins that she was playing with, but so that happens every couple months. Everybody gets kind of rotated in, shifted around. Bev, is in control of the bullpen. Who's going up to bat next, right? But the Raj has the power to insert themselves in whatever courtroom they wish, so long as it's in the county over which they preside. So meaning that Bev cannot go and assign herself to a case being tried in Essex County or Dedham or Suffolk County, right? Only within Norfolk County Superior Courts. Auntie Bev took the unprecedented step of removing O'Shea in the Reed case, who, again, just backtracking real quick, this guy right here, who is reassigned to the main courtroom where her case was going to be heard. Bev saying, "Nuh-uh, I'm going to be looking at this one." And this was one of the very shady things, exactly, that she did that led to a motion to recuse from the defense, which I don't know if they'd be able to file another motion for that just based on the fact of, hey, this doesn't seem ethically right, and I don't think that circumstances seem, what was the word that they used to describe it? Exceptional, right? Or extraordinary, some kind of buzzword like that. I don't think you really consider this like extraordinary. Like, does she really need to be on the bench again for this case when just so much has come out in recent months? I don't know. What say you? But I feel like there might be another motion. And as we saw earlier today, I actually posted this. So not the date of the oral arguments regarding the SJC stuff. That's happening November 6th. Day after Election Day. That's going to be cray. But there is a new hearing, and I don't know who it's on the behalf of, if it's on behalf of the Commonwealth and some of the recent filings that they've made, or if it's on the defense's end, but I would be curious. There is a motion hearing. So 10 a.m., if you're in town and you want to go check it out, here's that info and you can go and do so there. But I mean, I would think this would be credible ground. And also for the mere fact that isn't there technically a conflict of interest? I mean, I don't know. I'm just a layperson. person. I have questions, right? But you would think that there would be a conflict of interest, being that she is also presiding over this case where Chip Proctor is also the lead investigator of. And there's a lot of crossover, like I said, in this season from last season, a lot of the same players, so including Beth. So I don't know if that's grounds to file another motion to recuse herself as judge, but I would feel like that is tying into some of the other stuff that we're going to talk about in a second. So, canola oil ultimately denied after investigating herself and finding that she was not biased at all. Bias Bev. According to her, there was no appearance of bias when Matt McCabe's brother and Jen McCabe's sister-in-law began calling canola oil Auntie Bev in social media posts, and then sent me a threatening message vowing to bury my corpse, so Turtle Boy's corpse, under the lawn at Canola Oil Seaside Cottage. So that's interesting because I didn't actually know the origin of Auntie Bev. I thought that was something that the mob, right? Us crazy pink people, as they like to call us in mainstream media, have coined her. But no, this actually came from Matt McCabe's brother, his alcoholic brother, and Jen McCabe's sister-in-law. And this was held up in court. I mean, how insane is that? Do you really have a line? So this is from Turtle Boy. Do you really have a line to Judge Canoni? Auntie Bev? Whose seaside cottage do you think we're going to bury your corpse under? Again, that is Sean McCabe. Sean McCabe had just called in an order asking Judge Bev to institute a trial by combat order against you. They'll be coming to bring you to me any minute now. And that, again, is Sean McCabe talking to Turtle Boy. So that actually came first, but he's got a clip here, so let's take a peek at this.
Meetings. In this last one, I think the person's name on the placard that was held up was Julie Nagel. I do not know her. I have never rented my house down the Cape to any.
And just listen how defensive she sounds, because if you're somebody like me who kind of jumped in during the actual trial, this happened during pretrial motions. And it's so wild now to dig in. Now that we know, and you're working your way backwards and watching, okay, we just saw the clown show that unfolded, but how did we arrive here? And now it's like, it definitely leaves more questions rather than answers. And this seems huge, but this is in regards to a in regards to this screenshot that was held by Eliza Little, right? From Sean McCabe. And maybe we'll even do like an episode where we'll rewatch some of these pretrial motions hearings, because these are absolutely gold. I mean, you just find so much, and like I'm curious to see how the defense will navigate through some of this stuff going forward. But I mean, in the grand scheme of things, I don't know. I don't know if this would be enough to get her to recuse herself. Not this necessarily, but the fact that she's not technically supposed to be rotated out. So I don't know.
Meetings. In this last one, I think the person's name on the placard that was held up was Julie Nagel. I do not know her. I have never rented my house down the Cape to anybody, and I don't spell my name the way it was spelled on the placard, and I think counsel are well aware of that.
So Bev's mad because she's like, well, I don't spell my name like that. So clearly, also too, there's a thing called autocorrect Bev. And we know that people are notorious for spelling names wrong or leaving some names out in matters regarding Norfolk County investigations. Like, I have a friend named Sarah, and Sarah doesn't spell it in the traditional way that most people with the name Sarah spell their names, with an H at the end. She has no H at the end of her name. It's just S-A-R-A. Sarah. Still the same name, but if I went and spelled her name wrong, that wouldn't make her name any less Sarah than if I spelled it without the H. So, you see what I'm saying here? It's like, it's just so really, like, this is what we're getting so I can't believe it. Like, Julie Nagel, like, she's just can't even believe it. Can't even believe it. Now, as it turned out, she does, in fact, own a seaside cottage, and Sean McCabe lives just a couple of miles from the house in Barnstable. Throughout the trial, Cannoni was incredibly biased towards the Commonwealth, so he's just kind of highlighting a couple of key points that we all kind of have known about, right? It was just odd how determined this extremely biased judge was to stay on a case in which she claimed she was not biased at all, despite the fact that her brother, and this is the hugest thing for me of all, it's like, fine, you want to argue over semantics of, oh, I don't spell Beverly this way, I spell it this way, or, oh, I don't know a Julie Nagel, I've never rented my seaside cottage to anybody named Julie Nagel, and it's like, well, do you have an Airbnb listing? Like, I don't know. I'm asking. These are questions that I would have, right? And maybe you don't know her directly, but maybe you know people that she knows. And maybe that's how she rented that cottage. But, whatever. Let's put that all aside and say she's telling the truth. Whatever. This right here should have been the total, like, hey, I'm going to do the right thing because, yes, my brother represented Chris Albert, the king of D&E Pizza, the worst pizza shop in Massachusetts, conservatively. Represented Chris Albert in his 1994 case when he went to jail for 6 months for hitting and running over Peter Berger, a foreign exchange student, in a highway hit and run. But again, as long as she's going to be the Raj, or as long as she was the Raj, right? There is no way that she's going to pull herself off of this case. And I don't know, again, it is odd. Why would she want, like, what does she have to lose? Like, are you particularly close with the Albert family? Like, this is why people think that you're biased, girl, because somebody would look at this and say, yeah, I know this was, decades ago, and it was my brother who represented him, not me, but it's just too close for comfort for me, and I'm going to do the ethical thing and just give it to somebody else and avoid the S show that is going to follow me in the weeks and months leading after. I mean, what kind of crazy pills were you taking that day, girlfriend? Unless you like the drama. She could be somebody who just loves drama. I don't know. So justices, including Cannoli Oil, are being rotated out of their current courts. And in the next sentence, again, going back to the statement, it says she's not being rotated out with no explanation as to why. This doesn't clear anything up. It only verifies that she should be out, just like she should have been out last July. But the court is taking the unprecedented step to keep her on in the Reed case. I mean, it's like, I think we know why, but it's like, girl, if you're trying to prove that you're not biased, this is not a good way to do it. Also, almost as if they know that this is the only way to ensure that Reed doesn't get a fair trial. I mean, hello, like the ARCA thing is the biggest thing. The fact that you're not allowing them to disclose to the jurors that, hey, we didn't hire these guys. No one's insurance companies hired these guys. The prosecution clearly didn't hire them. So who hired them? No, it wasn't Turtle Boy conspiring because of this clown show circus that you set up in your courtroom, Bev, about why Turtle Boy shouldn't or should not be in the courtroom, and he's not technically a member of the press, right? Because he's just a blogger, right? He's just a blogger. Unbelievable. And it's like, after a while, like, you have to think, is this real or is this fantasy, right? Are we in a movie or is this real life? And this is actual real life. So she, for this very reason, because of extraordinary circumstances, whatever those may be, right? That somebody's got to preserve the meatballs before they get too moldy for January 27th. Somebody has to. And it's going to be Bev. She's going to take one for the team. So she will be making her guest star appearance at the next court hearing date for the motions hearing, on November 13th. Which, again, if it's streamed, we will stream it here. I'm going to make more of an effort to go live during the day. It's just hard sometimes with my work stuff. But I mean, yeah, if we could get a different judge, we might actually have a shot at getting some important information entered into discovery. Just the simple things, the little things, as Lunchbox Lely likes to say, right? The little things. It's the little things. Like the fact that the FBI hired ARCA to investigate the investigation that was conducted by the state police. But hey, like, again, we're the crazy mob, right? We're the conspiracy theorists, not them. Not them. What are they conspiring against, right? So that was the big thing that I wanted to go over today. But like I said, there was also tons of other news, including the next installment of the Better Letters Part Trace that exposes Meatball and all his meatballness and Ken Mello, this special prosecutor that was handpicked by Meatball to prosecute Turtle Boy in his case. Well, it seems like the two were participating in some not so ethical round of grab ass during the initial, I guess, proceedings or to secure the prosecution indictment of Turtle Boy and these bogus witness intimidation charges. So it's about 11 pages long. We're going to go through it now. But just to give you a little bit more context of what we're going to read, because I haven't read through the whole thing word for word. And I'm sure a lot of you have already seen Melanie Little's live stream of doing it. She's a lot faster than I am getting this stuff out to you guys, but definitely go check her, read out through, especially if you want more of a lawyer perspective. But just to give you some of the highlighted cliff notes before we dive in so we know what we're walking into, a lawyer for Aiden Carney, so our boy Mark Betterow, who's charged with intimidating witnesses in the Karen Reed case, said Thursday that authorities are lying about data extractions conducted on 2 of his cell phones seized at the time of his arrest and are trampling his free speech rights by prosecuting him. That's just some more background about the Karen Reed case, which we all know. Her lawyers say she was framed and that O'Keefe entered the home owned at the time. Sorry. Boston Community Grand Jury, Thursday file. Okay, here. Thursday's filing contained a letter Betterow sent to retired Judge Robert C. Cosgrove, whom Norfolk District Attorney... I didn't actually know he was a retired judge. Holy smokes. Norfolk District Attorney Michael W. Morrissey. It should be the... You're spelling meatball wrong, Boston Globe. Retained as a special prosecutor for Carney's case, which charges him with harassing and intimidating people who were in the Canton home on the night in question and some of their relatives and friends, which he has obviously pleaded not guilty to. In the letter that we're about to read, and then, again, I think this is the most explosive one yet, and I mean, the defense now calls Mr. Meatball to the stand? I don't know, but they're definitely going to be calling Ken Mello. You bet your bottom dollar if they could find him wherever he went off to, right? Said in Carney's phones were seized when he was initially arrested on October 11th, 2023, so a little over a year ago. For approximately 1 year, the Commonwealth has claimed or implied that Mr. Carney's cellular phones have not been searched. These representations are patently false. Bang, bang. That's what you call a bang, bang. Betterow said Morrissey and Fall River attorney Kenneth Mello, another lawyer retained as special prosecutor for the Carney case, have known since October 2023 that State Police Detective Lieutenant Brian Conehead Tully searched the devices and that Tully's agency extracted data from at least one of them before October 31st, 2023. Attempts to reach Morrissey's spokesperson, Mello. So David Traub literally pieced on out, like, I think right after this, right? Like, David Traub was like, nah, this is too much now, Meatball. You're asking too much of me now. I ain't getting paid enough for all of this crazy. So David Traub was not reachable, and then he pieced out. Mello and Cosgrove also weren't available for comments. Betterow wrote that Reed's lawyers haven't received any phone data from prosecutors' information the government's required to turn over under discovery rules. He said Mello told co-defense counsel Tim Bradel via email in November 2023 that state police wouldn't search the phones until separate issues regarding them were resolved in court, even though troopers had obtained a warrant to do so. And it's been something like 300 days plus now at this point that he's gotten his devices back. In a previous email dated October 19th, 2023, Mello told Bradel that Tully will cease any further searches of the phone until the court could rule on certain related matters. Betterow wrote, he said Carney's defense team recently came into possession of several data extraction points from Carney's phone, which Betterow included as exhibits in the file. Those reports clearly indicate that Tully searched the phone in October 2023. He said Carney's defense team recently came into possession of several data extraction reports from Carney's phone, which Betterow included as exhibits in the filing. Those reports clearly indicate that Tully searched the phone in October 2023. Betterow writes. So let's just take a look. You can't really make out what a lot of them say or really the context of which, but again, the important thing is making out as much of the date as possible. And I mean, this looks like September, late September. right? This is October 3rd. October 5th, that looks like. So, yeah. I mean, it's all right there, buddy boy. It's all right there, unless you're going to try and pull an Ian Whiffen and say, oh, the data does not exist like the limit, but the limit does exist in this case, right? And so does the dates. The dates do not lie. State police spokesperson declined to comment, citing the pending criminal proceedings. It is outrageous that the defense obtained evidence in your actual possession related to alleged intimidation of named witnesses from a third party rather than from the Commonwealth, who was obligated to disclose this evidence to the defense several months ago, but instead has repeatedly denied its existence, which is a reason why. And again, I posted this the other day on my community tab. Our friends Marshmallow and Meatball are both on the Brady list for prosecutor misconduct. So, pretty wild times at Norfolk County High, wouldn't you say? Betterow did not identify the third party who provided the data to the defense, but he did provide some related insight into the early stages of the investigation against Carney. So again, I want to give you context because as I'm reading this, I'm also learning too. On September 28th, 2023, Betterow wrote Reed witness Chris Albert sought a restraining order against Carney during a public hearing in Stoughton District Court, where a judge denied the request. Carney wrote about the hearing later in the day on his website, I'm not going to say blog, on his website, prompting another Reed witness, Jennifer McCabe, to text an unnamed person that someone from the court leaked it right away to Carney, Betterow wrote. McCabe's message, Betterow wrote, was forwarded to Meatball, who included it in an email he sent to trial court administrators from a personal iCloud account expressing grave concern about the alleged leak, even though the hearing was a public proceeding. So, my question, Meatball, is who are you really playing for? Is it Jen McCabe? And why? What does she have on you? I'm just so curious. What do the McCabes have on? Or is this all just to help? I don't know. Like, were they contributors to your fundraisers in the past for DA, right? Are they giving you money? Do you have dirt on them? Do they have dirt on you? What about the Albert? I mean, it's just so bizarro. Why would somebody put their career on the line for Miss Houselong to die in cold and protect and go to these extreme lengths to protect her? Morrissey's personal email, which Betterow included in the filing, also named a Stoughton District Court employee, Michelle Littlefield, as a leading individual who presents as a possible leak. Morrissey wrote that his office was informed by multiple parties that shortly after the restraining order hearing, Carney was provided with the entire affidavit, which again we saw in the screenshots that were provided in Mark Betterow's letter as part of Exhibit A. There is no way he would have been aware of the proceeding without an insider working in the courts or just attending a public hearing or just gathering information just as every single reporter would do. Like, that's how the news works, right? If a hearing is open to the public, guess what? Anybody can go. Anybody can sit in and take what they've heard and share it online with their friends and family, whatever they want to do with it, because it's public. That's what public means Morrissey. A spokesperson for the trial court said Littlefield was placed on paid leave in October 2023 and terminated the following month. Littlefield could not be immediately reached for comment. Bettero's filing was previously reported by the Boston Herald. This is a statement from Morrissey to the trial court officials. We are extremely concerned about the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage to a witness, and an ongoing homicide prosecution must be a violation of court policies or a potential violation of law. So he's like texting his buddies or emailing his buddies and saying, hey guys, be afraid of the turtle. And there's going to be a hearing about all of this in December, on December 2nd. So that'll be wild. Meanwhile, it's like, why are all of these people going way out of their way to protect the person who Googled with any like actual traceable evidence that they were aware a crime took place? The person who made the 911 phone call and Googled how long to die in cold. Why is Morrissey going so far to protect him? Protect her? Protect Colin Albert? Like, what is it? I'm really trying to understand. Like, you're the DA, dude. Like, what do they have on you? They have to have something on you where maybe they've contributed in the past financially to you, but unless Brian Albert has something on him, and I imagine that if anybody would, it would be Brian Albert. And I'd be terrified of him. Absolutely terrified. So let's read this letter. What do you say? The birthday Bettero letter, right? Okay, so October 17th. And I gotta say, I don't feel bad for Robert Cosgrove because, like, you're actively choosing to participate in this clown show. But if I were you, I would dissociate and run. Run! Hang up the phone. Do not take the call. No matter how many times Meatball tries to reach you, even if he sends his girl Maura Healey or Andrea Campbell and they're tapping you for help, don't answer the call. Just hang up the dang phone. It ain't worth it. It ain't worth any amount of money they're possibly paying you. Because this is the hill that you will die on, and no one will forget or forgive. We are scheduled to appear in Norfolk County Superior Court on December 2nd, 2024. See, like, already we see a difference. Like, Mark Bettero gets the dates right. Like, he gets the years right. He spells things correctly. He doesn't leave names out. Like, it's already a big difference from what we've seen in communications involving Mr. Meatball. To address issues related to the Commonwealth search of Aidan Carney's cellular phones, to date, the defense has not been provided with any data or extraction reports from Mr. Carney's devices, which have remained in the Commonwealth's possession since the Massachusetts State Police seized them on October 11th, 2023. For approximately 1 year, the Commonwealth has claimed or implied that Mr. Carney's cellular phones have not been searched. These representations are patently false. Norfolk County District Attorney Michael Meatball Morrissey and Special ADA Kenneth Marshmallow have known since October 2023 that MSP Detective Lieutenant D.L. Brian Conehead Tully searched for Mr. Carney's cellular phones and that the MSP extracted at least one of them prior to October 31st, 2023. We recently came into possession of several pages from a Celebrite extraction report of Mr. Carney's cellular phone, footnote 1, so Exhibit A. The Celebrite report identifies the owner of the extracted Apple device as Clarence Woods Emerson, which is a pseudonym used by Mr. Carney on Facebook, which again we just saw. And proof that it was searched by Conehead Tully in October 2023 during an investigation orchestrated by Meatball into alleged witness intimidation of Chris Albert and Jennifer McCabe by a Stoughton court clerk and Mr. Carney. It is outrageous that the defense obtained evidence in your actual possession related to alleged intimidation of named witnesses in the indictments against Mr. Carney from a third party rather than from the Commonwealth, who was obligated to disclose this evidence to the defense several months ago, but instead has repeatedly denied its existence. If you watched any of the hearings, which a lot of them they're like crappily recorded through audio, like a Zoom, like directly from Zoom. There's no pool camera or anything usually, which is insane to me because you would think like this is especially huge, and I expect more media stations to be present at that December 2nd hearing for sure. But I mean, like, this is why they're on the radio. Like, this is why, right? DA Morrissey launched the investigation, which relied upon the MSP's search of Mr. Carney's cell phones on September 29th, 2023. Exhibit B. This was after he engaged Mr. Marshmallow to handle any investigations involving Mr. Carney due to a conflict that arose after Mr. Carney's dogged reporting exposed information that persuaded a large segment of the public that Norfolk County DA's office and MSP framed Karen Reed for the murder of John O'Keefe, which almost overnight created the worldwide Free Karen Reed movement. Thanks, man. Like, props for you. Like, that's chef's kiss. Despite similar, if not worse, so another footnote, conflicts with Mr. Carney, the Norfolk County MSP Homicide Unit has not recused itself. D.L. Tully is leading an investigation in which his two direct subordinates, Chip Proctor and Bukwacki, are alleged victims of Mr. Carney. And that's another thing, too. It's like, there's so much crossover. This is not the crossover episode we asked for. It's not. Like, we don't want the same villains returning for season 2. No! We want a new cast of characters. Plus, Bukwacki's too preoccupied on the Great Duck Hunt of 2024, right? So, he's a little busy right now. He's got those 5 unpaid vacation days he's got to make up for with some overtime. Like, he's a busy guy. So, like, why is he gotta be, involved in any sort of investigation relating to Aidan Carney? And I'm fairly certain Bukwacki was also there to assist in the arrest of Aidan Carney as well, too. I believe he was present. Tully and Chip Proctor are presently under MSP internal affairs investigation, and Bukwacki already has been disciplined for their inappropriate conduct in the Reed case, which bolsters the credibility of Mr. Carney's reporting on the Reed case. This obvious conflict, combined with the Norfolk County MSP Homicide Unit's exploitation of the Massachusetts witness intimidation statute by utilizing it in favor of witnesses who, it continues down here, despise Mr. Carney. He's like really going in with the footnotes here. Hold on. And refusing to employ it against those who are aligned with Mr. Carney and or are critical of the Reed case exposes the unit's animus towards Mr. Carney and creates the appearance of an improper motive for investigating him. As DA Morrissey recognized in recusing his office, public confidence in the MSP and Norfolk County criminal justice system, which currently is dreadful in large part due, wow, he is coming in like with a little extra shade this time around. Due to the MSP Norfolk County Homicide Unit's conduct on Mr. Carney's cases, the Reed case, including Chip Proctor's suspension without pay for his shocking and disgraceful treatment of Miss Reed, and the flawed Sandra Birchmore case, compels that the Norfolk MSP Homicide Unit would be replaced with unbiased investigators from another county. And then he links to this article as soon as 10:15, which I think this was the same article, actually, that mentioned Lynn Beeland beelining it all the way to the retirement line, right? To cash out her 401k, right? Lest there be any doubt that Mr. Marshmallow didn't know in October 2023 that Mr. Carney's phones were searched and at least one extracted, his failed attempt to indict Karen Reed and Mr. Carney for conspiracy to commit witness intimidation shortly before Miss Reed's trial, in which Mr. Mello elicited testimony from Tully that he searched Mr. Carney's cellular phones in October 2023, settles that question. See testimony of Detective Lieutenant Tully, pages 27 to 29. We are deeply troubled by Mr. Mello's misleading representations, which have left the court and defense with a false impression that Mr. Carney's devices have not been searched. See footnote. To be clear, we do not believe that Mr. Cosgrove has deliberately made inaccurate representations to the court and or defense. Rather, it appears that DA Morrissey, Mr. Mello, and Tully have failed to inform him about the true circumstances surrounding the searches and extraction of Mr. Carney's cellular phones. And that I will agree with. I mean, like, he's just the new hired gun who maybe is just trying to, make some vacation money or, some money he can piss away at the gambling table. I don't know. But whatever this gig is for him, I would highly recommend, in my completely non-lawyer, non-certified opinion, to just cut and run and like cash out what you can. I'm sure obviously these are billable hours, you put in the work, but I mean, to be clear, I read that. We are deeply troubled by Mr. Mello's misleading representations, which have left the court and defense with false impression that Mr. Carney's okay, so I read that. Put simply, it is undeniable that the Commonwealth has failed to disclose any evidence from Mr. Carney's devices, despite Mr. Marshmallow's, Tully's, and DA Morrissey's knowledge for more than 1 year that such evidence has been in the Commonwealth's possession and that at least one of Mr. Carney's cellular phones had been extracted. DA Morrissey's fall 2023 investigation of Mr. Carney, like the italics. Mr. Mello has certified that his services as a special assistant district attorney incurred as of September 20th, 2023, Exhibit C. I just want to scroll down to Exhibit C. Oh, this is E. This is D. Where is C? There we go. Oh, no, this is B. C. Here we go. This is W9. W4. Exhibit C, okay. DA Morrissey officially authorized Mr. Mello's engagement on September 26, 2023 Exhibit D. Thus, DA Morrissey agreed and understood prior to September 29th, 2023, that Mr. Mello was a proper official to handle investigations related to Mr. Carney's alleged intimidation of witnesses in the Reed case. On September 28th, 2023, Chris Albert, a witness in the Reed case and alleged victim in the 2023 indictment, sought but was denied a protective order against Mr. Carney before Judge Daniel O'Malley of the Stoughton District Court. This application was heard and decided in a courtroom open to the public. Later that day, Mr. Carney published a blog about this matter. That evening, Jennifer McCabe, another witness in the Reed case and alleged victim in the 2023 indictment, complained in a text message to an unnamed individual. I know it's late, but I am horrified that Chris didn't get it, and I am even more disgusted that for the second time, someone from the court leaked it right away to TB. I mean, even, like, obviously, why are you so... This is what gets me so, like, twisted, right? Why are these people so intimidated by a blogger? He's just a blogger. Well, then why are you seeking restraining orders and claiming crying witness intimidation? Miss McCabe, footnote. On May 30th, 2023, Miss McCabe unsuccessfully sought a protective order against Mr. Carney in the Stoughton District Court. This application also was decided in a courtroom open to the public. Yeah, Jen. Sorry, girl. Sorry, girlfriends. Miss McCabe's message was forwarded to D.A. Morrissey, who included it in an email he sent the following day to Stacey Fortes, Chief Justice of the District Court, Thomas Ambrosino, Massachusetts Trial Court Administrator, Philip McHugh, Deputy Court Administrator, and Judge O'Malley. Oh, and Lynn Beeland, right? So Judge O'Malley, who was the presiding judge, in this protective order that didn't go through for Chris Albert, who just denied it, gets hit up in the wee hours of the morning or the next day by Meatball. Now, what I'd be curious is, she's so worried about this leak, right? Even though it's not a leak, because anybody could have went. It's public information. And let Turtle Boy know. But who are you texting that has Meatball's personal email? Like, that's what... Because if he's forwarding it from his personal iCloud account, unless he forwarded it from his DA's email and then re-forwarded it again. I'd be curious to see when we look at the exhibits, we'll be able to probably tell how that was forwarded over, but it seems like the person screenshotted the text Jen McCabe sent and hit Meatball up directly, and then from there he probably clicked on his phone, right? Probably clicked on his phone, hit the mail application on his phone, which is synced to whatever, again, your iCloud account is, not your Massachusetts District Court official county email account, right? So that's kind of the way I'm envisioning it, is they probably texted it to him. He probably clicked on the link and then was like, oh crap, let me forward this over because I'm in crisis mode. And I just don't have time to set my camera up and do a whole other video, guys. Like, it didn't really work out as well as I had hoped the first time around. Oh no, actually, I think this was before. Yeah, this was before the hostage video. This was before. But he's in crisis mode, so he uses his personal email account Email addresses used by employees of the Norfolk DA's office end in @mass.gov. The email address used by DA Morrissey for his September 29, 2023 message, but again, by that point, he would have already recused himself, and Mello would have been the guy to involve himself in any way, shape, or form. It's like these people don't know what the word recuse means. Like when you recuse yourself from something, it means you're stepping away completely. It means you have no part in this anymore. Like, I don't know, like there's no special, extraordinary circumstances. There's just not. It's either you're in or you're out. Mello was supposed to be the guy handling anything involving this prosecution. That's why you paid him however many hundreds of thousands of dollars he made billable to you, which is associated with an individual's personal Apple account. Yeah, so again, the way I'm seeing it is somebody probably texted it to him. He probably clicked on it, right? Or he probably saw it. He probably saved it, clicked on the Apple mailbox application on his phone, and then forwarded over like that. That's the way I'm seeing it. To communicate with numerous high-ranking court officials, including the judge who denied Mr. Albert's application for a protective order, exactly, about official business he described as a matter of grave concern. Someone in the Stoughton District Court shared an affidavit that was prepared by a witness in the Commonwealth versus Reed psych murder case with Mr. Carney. So, an Aliving case with Mr. Carney. So, this is clearly spelled incorrectly. I mean, Karen Reed's name is like you read a book, right? So a lot of people have said, like, was this a typo or was this an intentional? And at this point, there's too many circumstances stacking up where I feel like everything is intentional. There was no way. Everybody knows, and it's not even like it's a difficult name, right? Or you went from Reed, R-E-E-D, to R-E-I-D or something like that, right? It's Reed, like you read a book. And at this point, we're so deep into it and deep into the investigation. They're in your county, right? This is the most high-profile case in your county at this time. And you just happen to spell her name wrong? Absolutely no. Absolutely no. Because you don't want people finding out what you were doing, Meatball. We're on to you, buddy. We're on to you. You ain't that slick. Without elaboration, DA Morrissey named court employee Michelle Littlefield as the leading suspect of, I guess, the leak. That same day, Catherine Peter, an MSP source against Mr. Carney, see October 8 letter, which we read through my last video, tweeted that Mr. Carney would be arrested on October 10th, 2023. He was arrested on October 11th. In an October 3rd, 2023 Facebook post, Ms. Peter publicly identified Ms. Littlefield as the target of the unpublicized investigation, posted her picture, and announced that Ms. Littlefield had been suspended as part of the investigation. So let's go to this Exhibit E, just really quick. This lovely lady, like, she's so dumb. This lovely lady is Michelle Littlefield. If you're down at Stoughton District Court, you can rest easy. Your personal information is safe for the time being, as she was perp walked out today and put on suspension pending an internal investigation. What is it that Karens like to say? You work for me? What? Like, well, Michelle, you effing scumbag. I mean, really nice. Like, this is the mouthpiece for the Norfolk DA's office, right? Just another mouthpiece. Catherine Peter, stand-up citizen. Respectable. We want more people like her. And your decision to share sensitive information entrusted to you through the court to further harass and stalk a civilian really caught up quick. Trust and believe it's going to follow you around too. You will be getting more attention soon, as will our new friend Janelle, who is the 911, I think, operator, who Turtle Boy was talking to as well, too. I hope both your careers were worth it, and then, like, just completely doxed her. Like, which was not public knowledge. So it's like, these people are so dumb. So dumb! He expressed concern that the Reed case witnesses had lost faith in the courts and that the actions erode the trust and integrity between the courts and the public and the relationship with the DA's office. We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and damage.
Emotional damage.
It's just so frickin'. It's a clown show. Clown show. It is a clown show. 2 witnesses in an ongoing homicide prosecution must be a violation of court policies or potential violations of law. Like, did you go to law school, brother? Like, come on now. We also understand that Aidan Carney had also immediately requested copies of the FTR record that was made on 9/28/23. Again, there is no way that he would have or should have known that a hearing took place. Like, that is public information. That's not... He can find out if a hearing is taking place or not. Like, it's not... What? Like... Exhibit B, DA Morrissey concluded by demanding that these matters be resolved immediately. Immediately! And that he would await your advice. Advice or, like, do it. Like, don't grant Jen McCabe's RO. Like, after Mr. Carney's October 11th, 2023 arrest, see other footnote, transmissions from 7:53 a.m. on the day of Mr. Carney's arrest confirm that MSP officials assigned to arrest Mr. Carney, including Tully, heard from KP. It was the same thing yesterday, 2 older kids getting on around the same time, but it was 8:30. And yeah, you can check out that audio recording too on TB Daily News. It's literally when they're on their way to scoop him up at his kid's bus stop, which is just so gross and like disgusting. It's like, I hate when people like bring people's kids into it, right? Where it's like, we got to make a point in a statement and do this in front of or nearby. Like it just... It doesn't sit well with me. It's like, okay, like, we know that you're scumbags, but that's just like another level of scumbaggery, is to literally lie in wait and follow this guy's kids' school bus, like, and make a whole big scene out of it and like embarrass his kids, and like, it's just... It's not cool. There's no need for it. I mean, it's just a clear representation of just how much scumbaggery there is in the MSP and within the Norfolk County DA's office. Remarkably, it appears that Ms. Peter participated in the MSP's apprehension of Mr. Carney by surveilling him at their behest. And it's funny because it's like she's talking about stalking and harassing. Meanwhile, wouldn't that be characterized as stalking and harassing? Right? Like, I don't know. What say you? DA Morrissey concluded by demanding that these matters be resolved immediately. I await your advice. Okay, I read that. His cellular phones were seized and maintained by Tully. At approximately 9:15 a.m., the MSP obtained Mr. Carney's passcode and gained access to them. Within 1 hour, Miss Peters sent a childish and harassing DM on Twitter X to one of Miss Reed's attorneys. We know you're involved in Aidan Carney's little witness harassment game, and your texts with him, see footnote 8, have already been making the rounds. Buckle up, Buttercup. Like, just, like, what a weirdo. Like, who does that? Who hits up the defendant's attorneys on Twitter? Like, what is the point? Like, are you just stewing because you have nothing better to do than hit up Davey Gennady or Alan Jackson late at night? Like, it's just weird. Don't you have friends, like, kids to attend to? At least a couple of them left, right? Tully has testified that he viewed text messages between Carney and Miss Reed's attorneys on Mr. Carney's cellular phone in October 2023. And again, they were ultimately not indicted on conspiracy of witness intimidation harassing, right? They weren't. The grand jury didn't indict them. So there we have it. Miss Peters' baseless implication that Miss Reed's attorney engaged in witness intimidation is another example of her pattern of being completely unhinged. Of engaging in violations of MGL. You see, yada yada. So, investigation demanded by DA Morrissey. These materials included copies of DA Morrissey's September 29th, 2023 email and several pages from a Celebrite extraction report from one of the cell phones seized from Mr. Carney on October 11th. Footnote 10. Pages of the extraction report provided to Miss Littlefield omitted a May 30th, 2023 message in which Mr. Carney was told that a local reporter observed the proceedings where Miss McCabe was denied a protective order against Mr. Carney. On October 19th, Marshmallow emailed co-counsel Timothy Bradel that he did not know how far the MSP had progressed in any review of Mr. Carney's devices. A few hours later, after speaking with Tully, Mr. Marshmallow updated Mr. Bradel. Tully is the only individual in possession of the electronics seized, and I can confirm he will cease any further searches until this matter can be addressed by the court. You have my word on this as an officer of the court. If you have to say that explicitly, like in an email, like that is, you're up to something. Something stinks, and it ain't Tim Bradel. From October 20th to November 8th, 2023, Mr. Bradel asked Mr. Marshmallow 3 times if Mr. Carney's phones had been imaged, which would have made it unnecessary for the Commonwealth to maintain possession of them. Exactly. It's like if you already did the extraction and you imaged everything and got what you needed, why the heck does he still need to be holding on to this device? He doesn't, or these devices. Marshmallow tellingly ignored these inquiries. On November 16, 2023, Mello reassured Mr. Bradel that Mr. Carney's devices had not been searched. I gave you my representation that we would not examine the contents of the electronic devices without sufficient prior notice to you. Please know that we obtained search warrants this morning for the full contents of said devices. I have asked Tully, and he has agreed to refrain from executing said warrants. Your client's devices will not be examined prior to the court's ruling on your motions. The defense has not been provided with these warrants or underlying affidavits. We demand immediate production of these documents. So there's warrants. Great, awesome. There's affidavits. So where are they? It's pretty easy to procure them, is it not? This is just so insane. So they're withholding evidence. They're literally withholding evidence from the defense. And again, we've seen this in the Alec Baldwin case, and Carrie Morrissey was the whole reason why the charges against Alec Baldwin in that case got dropped. And the judge was like, no, we can't continue on to this because you were supposed to share evidence. You deemed not to be of evidentiary value, which is not up for you to determine. That's up for the defense to determine whether or not they want to use it to present the best possible case that they can for their client, because that's called a freaking fair trial. That is called due process. You don't get to pick and choose what you're going to share with them, especially affidavits and alleged search warrants, right? This is somebody's life at hand. This is absolutely crazy. On November 28th, 2023, at a hearing in the Stoughton District Court, Mr. Mello couldn't have been any clearer in representing that Mr. Carney's devices had not been searched. State police and the investigators have not perused the material. It is in pristine form located on the defendant's devices. Court then asked Mr. Bradel if he had been advised by the government that they hadn't started the search, that there's been no search done. Mr. Bradel indicated that it was his understanding that no search had occurred. Instead of clarifying the obvious misimpression that the court and Mr. Bradel believed Mr. Carney's devices had not been searched, Mr. Mello merely replied, "We would not investigate. We would honor our commitment to further not investigate until this matter is determined by the Superior Court." Like, what? That's the most non-answer answer ever. Deny, 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 deny. And it's like, for anybody who's like, yeah, screwed Turtle Boy, lock him up and throw away the key forever. It's like, I guess you're prone to gaslighting. Like, you're just surrounded by people who have gaslit you your entire life. Because this is literally what gaslighting is. If you look up the definition of gaslighting, you will see Marshmallow's face in there. Front and center. You will see Tully's face. Front and center, side by side. Conehead, meet Marshmallow. Add a meatball in there, you got a really weird looking s'more. That is what gaslighting is. It's like, not to drag people, like, but it's true. It's true. It's like, this is what gaslighting is. It's not answering questions. And just saying, I don't know what you're talking about. Like, I don't know. What is he talking about? I never saw the thing. Like, we never searched the phones. And right in your face. Video of this proceeding is available at Cablecast public site /show. So here you go. Like, folks. Oh, and it's clickable. Wait, let's see. Is it going to pull up? I wonder. Taking forever. It's probably going to break my internet, so I'm not gonna. But you can click it and check it out there, because it's public. It's a public proceeding. Mr. Mello further stated that if he provided the devices to the defense, Mr. Carney might delete data and thereby impair the integrity of a later extraction. It's just like the same argument that Lally made to the jurors about, like, we can, like, further inquire about what your verdict was and, like, hear you out and bring this to the attention of the court. But, like, if we do, we can't promise that your identity won't be leaked. So I just want to let you know, like, by the way, like, that's the same exact answer. In other words, Mr. Mello gave the court and defense the clear impression that Mr. Carney's phones had not been searched or imaged for extraction when he knew the exact opposite was true. See Exhibit A. It strains credulity. I feel like that was a nod to Melanie Little. That Mr. Mello, who frequently discussed the investigation with Detective Lieutenant Conehead in October 2023, didn't know on November 28, 2023, that D.L. Conehead had in fact searched for Mr. Carney's devices and that at least one phone had been previously extracted. See footnote 13. Where is the footnote? Oh, here it is. I got distracted by this other, it's a not clickable link though this time. Mr. Mello's dubious representations are another topic that we intend to examine him and Tully under oath in support of our pending motion to disqualify Mello under Rule 3.7a of the Massachusetts Rule of Criminal Procedure. That is what we call a bang-bang, folks. Mr. Mello's misleading representations and failure to disclose evidence he was obligated to provide to the defense several months ago likely violate Rules 3.3a, 1, and 3.4a and d of the Massachusetts Rules of Professional Conduct. I would love to see Mark Betterow just, like, hand, like, the booklet for professional conduct and have Tully and Mello just read it word by word out loud and be like, hey, but, like, that wasn't done right in this particular case. Like, but you didn't do that right. For more than 1 year, the Commonwealth had steadfastly refused to return Mr. Carney's devices. Even worse, you haven't disclosed to the defense any evidence contained therein. Instead, the Commonwealth has repeatedly maintained that Mr. Carney's devices have not been searched. The Commonwealth's obfuscation, oh boy, that's a big one, has harmed Mr. Carney professionally and it has prejudiced him as a criminal defendant. Yeah, I mean, it's like you go anywhere and you search Turtle Boy And the first thing you see is, you see his mugshot, you see witness intimidation, criminal defendant, just a blogger, leader of a crazy mob of pink people. It's just absolutely horrible. Horrible. It's a horrible mischaracterization of what he's doing and what he's fighting for. He's fighting for every single one of you. Every single person who's like, lock him up and throw away the key. He is fighting for your right to literally say, lock him up and throw away the key. Like that is what he's fighting for. Your rights too. Your First Amendment rights too. It's crazy. And they're just like in broad daylight, they're just doing this for the whole world to see. And this is why they are the laughing stock of the nation. Like, no offense for any of you guys who live there, but it's true. Norfolk County is at least the DA's office, right, is the laughing stock of the country. He's entitled to data on his phones that is necessary for him to do what he does, right, for money. He earns a living. If you earn a living from it, guess what? It's a professional job. It's a career. So let's call it what it is. Like, he's a reporter. He's a journalist. He's an independent journalist. And he has an absolute right to review evidence to which he is legally entitled. And again, if it's in open proceedings and it's public information and you can make public requests, Freedom of Information Act, right? That's not criminal behavior. And it's like, if he asks for something and somebody tells him, no, I can't give that to you, then okay, like, there's no problem in him asking for information. And regardless, it was a public hearing. So in regards specifically to the Chris Albert end of things, but on April 23rd, 2024, Mr. Mello was ordered to disclose by May 8th, 24, any evidence in his possession that was subject to automatic disclosure under Rule 14. So then they include this linkity link here, which, I mean, I don't know. I'm not going to paste it because it's probably not going to load up, but given irrefutable proof that Mr. Mello and Conehead, Tully, and almost certainly D.A. Morrissey, I love the like low-key shade, have known that Mr. Carney's devices were searched, and at least one was extracted in October of 2023. The Commonwealth's failure to disclose any evidence recovered from Mr. Carney's devices and any extraction reports from his cell phone is indefensible, a clear violation of his due process rights to access material evidence and to fully prepare a defense. And again, that's true. There's privileged information between him and his attorney, documents, I'm sure, that were shared, reports of certain things, screenshots that he could share with his defense team to properly prepare for this upcoming trial. The defense believes that Mr. Carney is being prosecuted to stifle his First Amendment rights to report and opine publicly and loudly about alleged corruption and misconduct in the Reed case by the Commonwealth, MSP, and civilians who are now witnesses against him. We further allege that the MSP wanted to seize Mr. Carney's cell phones to improperly access his sources of knowledge about the Reed case and to review any information he possessed regarding a federal investigation into their conduct during the Reed investigation prosecution. I mean, would they come this hard at, like, literally any reporter ever? I mean, I always think about the Johnny Depp and Amber Heard trial, right? And Kat Barge, who likes to yell from the rooftop that Amber Heard is a victim when she was proven not to be. Like, she was. The court did not fall in favor of her side, but they fell on the side of Johnny Depp's. So we saw that happen in real freaking time. And it's just, you don't see anybody coming after, or Dan Wooten. Like, you wouldn't see this level of just somebody really trying to get into a reporter for asking questions, for digging for documents. Like, You just don't see that anywhere else unless you have something to hide or you're trying to protect certain people. Accordingly, pursuant to Brady versus Maryland, Graham versus District Attorney for Hampden District, in Rule 14, we demand any information, evidence in your possession, custody, or control regarding the seizure, search, and extraction of Mr. Carney's devices, including but not limited to true, accurate, and complete copies of any data searched and or observed, any extraction reports, search warrants. Let's see them search warrants, Tully. Affidavits. Let's see them, Tully. In support of search warrants when the devices were searched and extracted by whom? And it's like, I want to see a request for a search warrant. Like, was that even made as well, too, right? Or did you just start going through them looking for nudes, like Chip Proctor, right? You're subordinate. When they were searched, when they were extracted, by whom, any reports, email, documentation, any form describing the contents searched, searches, or extractions of the devices or communications between and among or to and from DA Morrissey, Mello, Tully, and anyone associated with the Norfolk DA's office or MSP. That would include their source, Kate Peter, would it not? Any of the individuals referenced in DA Morrissey's September 2020, 29th, 2023 email, Miss Littlefield, Miss Green, any other employees of the Stoughton District Court, Jennifer McCabe, and Chris Albert, and Miss Peter. Yep. We look forward to your prompt disclosure of the requested evidence and any other required Brady and Giglio disclosures that result from your discussions with DA Morrissey, Mr. Mello, Tully, or any other appropriate individuals regarding the issues we have raised about Mr. Carney's cell phones. Mark A. Bettero for the frickin' win. So let's just take a quick peek at this September 29th email. Right? So, I mean, I can't really tell if it was like something that he forwarded, but I'd be curious if he got it sent to his mass, like .us or mass.gov email, and then re-forwarded it to his iCloud account. Like, that's some premeditated BS. And this is, I thought this said AM. I was like, this is 1:53 a.m. Oh my God, he is spiraling. Okay, so 1:53 is on his lunch break, right? He's eating a couple of meatball subs, whatever, yada yada. I'm writing to express my grave concern with actions taken by an individual employed at the Stoughton District in regard to an affidavit that was shared with a blogger writing about an ongoing second-degree M case on 9/28. Like, I like how he doesn't even say which case it is. It's like, you're like, really, everybody knows who you're talking about, dude. On 9/28/2023, a witness in the Commonwealth versus Reed M case filed a request for an application for harassment prevention order, which was heard by Judge O'Malley. The application and affidavit was processed in the Civil Clerk Department of Stoughton District Court and presented to the judge, which after a hearing was denied. We were informed by the witness and others that shortly after the hearing that Aiden Carney, aka Turtle Boy, was provided with a copy of the entire affidavit. There is no way that he would have been aware of the proceeding without an insider working in the courthouse. The leading individual who presents as a possible leak is Michelle Littlefield. I mean, it's just, again, it's so crazy because you think about all of these stories that break all the time, all these aka whistleblowers, right? All these different cases, news reporter. It's like, how do you be an investigative journalist if you don't ask people questions, if you don't have sources, if you don't protect your sources, if you don't get information shared with you? And again, in this particular instance, this was a public court proceeding. So I imagine they were like, hey, by the way, like, this is going down. And they're seeking, and I don't know if he was aware that they were seeking this restraining order ahead of time. I mean, he could have been. Maybe he had an inkling that this would happen eventually, but... So this is the Jen McCabe text. And I guess this is this is from the Morrissey email attachment. And this is a screenshot from his blog. The above comments from a previous witness who also received the same treatment with their application for an HPO is attached. Also, the comments from Clarence Woods Emerson. Turtle Boy are attached. It's clear from the postings that Stoughton Court is directly involved in this dissemination of information affecting our prosecution of the Karen Reed case. From the comments from what... So, I mean, like, that is you literally admitting, bro, that you're afraid that this dude is going to expose you for framing Karen Reed. Like, that is literally what the sentence sums up to mean. It's clear that the postings that Stoughton Court is directly involved. So now the Stoughton Court is also involved in this conspiracy, guys. Like, now we got, oh my goodness, we got everybody. We got the feds involved. The ACLU, we got the Stoughton Court. We got everybody. Everybody is conspiring against Meatball. No more pasta nights. From the comments from one of the witnesses, you can see that they have been completely lost all confidence in the courts of the Commonwealth. You know who else lost all the frickin' faith and confidence in the courts of the Commonwealth? The name of the woman that you spelled wrong purposely because you're trying to cover up the fact that you're framing her for unaliving her boyfriend. Karen Reed. She's somebody who's probably lost faith and confidence in the courts of the Commonwealth, or at least in your county. I have to agree that the actions erode the trust and integrity between the courts and the public and the relationship with the DA's office. Do you? We are extremely concerned that the improperly disseminated court material unsolicited to a third party, which is continuing to cause harm and emotional damage to a witness in an ongoing homicide prosecution, must be a violation of court policies or a potential violation of law. We also understand that Aidan Carney had also... It's so weird. He's like writing this almost as like a defense attorney on behalf of a client. Like, is your client Jen McCabe? It's so weird. It's like, who wrote this? Like, this is so unhinged. This is so unhinged. These long paragraphs, like, very difficult to read, very difficult to find. And it's like the fact that you're like, or potential violation of law. You don't even know if it's a violation of law or not. You're the freaking DA, bro. You're the DA. Wouldn't you know? We also understand that Aidan Carney has also immediately requested copies of the FTR record that was made on 9/28/23. Again, there is no way that he would have or should have known that hearings took place. Like, I'm just curious about like all these people he's writing to, right? Especially like the ones that I feel like have no, like, absolutely no stake in the game. It's titled Stoughton District Court Issue. I mean, this is crazy. Caution, this email originated from outside of the organization. Do not click links or open attachments unless you recognize the sender and know the content is safe. And I wonder how many people open this and were like, Michael Morrissey? Like that Michael Morrissey? It's just so bizarre. It's so bizarre. Again, hearing took place. There are a number, but like, again, I wonder how many of the judges he was emailing like actually knew what the crap he was talking about, like knew what the duck he was talking about. Like, okay, cool. Not that like they wouldn't have heard about this case at that point, but I'm sure that they would have been loosely aware. But it's like, bro, I would have been like, why are you hitting me up? I have nothing to do with this. I'm not the presiding judge on this case. And in the fact of, what was it, O'Malley? O'Malley's like, I just denied this guy's request for a restraining order for a reason. Like, I didn't find that there was anything that warranted his life was being threatened, right? There are a number of concerns that we have about the possibility of having file ongoing motions or other requests for warrants before this court that will affect the orderly and fair administration of justice. These actions are completely unacceptable and must be resolved immediately. Immediately! I understand that you have to do an investigation that may take time, but you also have to provide us with some evidence and assurance that you've taken action so we can safely continue to use the clerk's office of the Stoughton District Court. Like, he is paranoid AF. Like, I could just see him, like, tweaking out at his desk, like, biting his, like, little sausage fingers until they start to bleed. Like, he is, like, unhinged. Maybe he's behind some of these troll accounts. I don't know, because the way he's writing, like, look at these long run-on sentences. Like, this is not somebody who is thinking clearly. We have a number of delicate matters before them on a day-to-day basis. I await your advice. And that's just such a weird way to end. I await your advice. Like, on the one hand, and the other hand, sorry, that's another Deadwood quote. You're saying, okay, I'm asking for your help and advice on this matter, but you're also telling them what to do. You're telling them, hey, there's stuff that I don't like going on in your court right now, and you need to figure it out, and you need to take action, because if you don't, then I don't think we can do business with you anymore. Like, that's not how that works. Like, you can't just pick and choose what courthouses you're going to do business with. That's not... They're not like a supplier that you hire out to get certain products for to stock your store with. It's a courthouse. You don't get to decide that, Meatball. I mean, my goodness. My goodness. Yeah, and then this is the text from Kate Peters. So I'll link this doc if you want to read it in full. You can without my commentary. Melanie Little also did a great readout and had Mark Betterow on himself as well to discuss this in more depth. So definitely go check that out. But my goodness, it was a busy week, and we didn't even get into like half of what happened last week. So stay tuned. More and more is going to be coming out over the next days and weeks. As we know, like I said, we're only a couple weeks shy of that SJC oral arguments hearing, but there is going to be that motions hearing. What, if anything, it is on the 13th. Maybe that'll be the first time that we hear from Mr. Brennan, the new special district attorney, customer service representative, mouthpiece of Michael Moore. I don't know, right? I don't know what they call it in Massachusetts, but the new special prosecutor who's going to be taking the lead in the Karen Reed trial coming up in the 27th. So we shall see. And as always, if you enjoyed today's content, make sure you hit that subscribe button. Make sure you hit the notification bell so you don't miss the next Karen Reed update from me. And make sure you hit that like button, because that tells the YouTube gods that this is newsworthy news. And it is. I mean, look at the amount of freaking corruption going on. And if it's going on in Norfolk County, you bet your bottom dollar, Buttercup, it's happening in yours too.